trial courts. As the lowest of the level of these federal court system are the trial courts, general courts that hear cases not specifically assigned to another court. A case involving contract violation would go before a trial court. Every state has at least one federal trial court called district court. Trial courts also include special courts, administrative agencies. Special courts hear specific types of the cases, such as cases involving tax evasion, fraud, international disputes, or claims against the US government. Within their areas of jurisdiction, administrative agencies also make judgments much like those of the courts. Courts in each state system deal with the same issues as their federal counterparts do. However, they may be ruled only in areas governed by the state law. For example, a case involving a state income tax laws would be heard by a state special court. Local courts in each state system also hear cases on municipal ordinances, local traffic violations, and similar issues. Appellate courts. A losing party may disagree with the trial court ruling. If that party can show grounds for review, the case may go before a federal or state appellate court. The state appellate court is, of course, the High Court, and the federal appellate court is, of course, the Supreme Court. These courts consider questions of law, such as possible errors by the legal interpretation in the trial court made by the lower courts. They do not examine the questions of the fact. There are now 13 federal courts of appeal, each with 3 to 15 judges. Cases are normally heard by 3 judges panels. Supreme Courts. Cases will not be resolved at the appellate level can be appealed to the appropriate state Supreme Court or to the US Supreme Court. So there are Supreme Courts at the level of the states because the states in USA are the sovereign states. So as the states are the sovereign states, well, all of them have their state Supreme Courts, and then there is federal Supreme Court for the Federation of the United States of America. If it believes that an appeal is warranted or that outcome will set an important precedent, the US Supreme Court also hears cases appealed from state Supreme Courts. Each year, the US Supreme Court receives about 5,000 appeals, but typically agrees to hear fewer than 200. Business law. Well, we can call it commercial law, we can call it mercantile law. Most legal issues confronted by businesses fall into one of the six basic areas, and they all fall under mercantile law: contract, tort, property, agency, commercial, or bankruptcy law. These areas cover a wide range of business activity. So we can talk a lot about them as we move ahead, and we'll learn about them in detail. And they are, so to say, the contract law, tort law, property law, agency law, commercial law, and bankruptcy law. Contract laws. First of all, talk about the contract law. A contract is an agreement between two or more parties that is enforceable in courts. As such, it must meet six conditions. If all these conditions are met, one party can seek legal resources from another. If the other party breaches, that is, violates the terms of the agreement, are put to a court, and the court will make the decision. Well, to explain it all, we need to understand the different content provided over here, such as agreement, consent, capacity, consideration, legality, proper form, and the fulfillment.